I just go according to what I see on the screen. There's Honorable China Dodovu. Honorable Dodovu, do you want to greet everyone?
Yes. I'm okay.
Okay.
I'm just going to be in the place where I'm okay, but I'm here.
Okay, thank you, Honorable Dodovu. Honorable Dodovu is from the Northwest Province. We have Honorable Dango from Gauteng. Honorable Dango.
I'm present.
Yeah, I thought you just greet us, but that's great, Honorable Dango. We have Honorable Mtetwa from KwaZulu-Natal, KZN Province. Honorable Mtetwa.
Morning, comrade. I'm a member of this committee. Thank you very much.
Good morning, Honorable Mtetwa. We have, oh gosh, Honorable Fisser from the Northwest. Honorable Fisser, I think you just joined. You can just greet all members.
Everybody, good morning. Honorable Chairperson.
Yes, Honorable Bartlett.
Honorable Bartlett, sorry. Yeah, no, I assume you called my name and I didn't answer. But thank you. I greet all the members in the committee. Thank you very much.
Thank you, Honorable Bartlett. Honorable Bartlett is from the Northern Cape Province. We have Honorable Nkosi.
Thank you very much, Chair. Good morning, everybody. I'm here, Chair. Thank you.
Thank you. Honorable Nkosi is from Mpumalanga Province. We also have Honorable Zandamela from Mpumalanga Province. Honorable Zandamela.
Morning, everyone. Thanks, Chairperson. I'm here. Thank you.
We have Honorable Mikalakis from the Free State Province. Honorable Mikalakis. Okay, I see he is with us. Anyway, I'm sure he can still introduce himself later. We have Honorable Mpayela from KwaZulu-Natal Province. Honorable Mpayela.
Yes, good morning, Madam Chair, and good morning, honorable members. Thank you.
I'm not sure if I've left out any other honorable member. Okay. I think I've covered all honorable members. Once again, welcome. And honorable members, we're meeting with the Independent Electoral Commission. I'm told that the chairperson of the commission is with us, Mashinini. If you can perhaps introduce yourself and your team to the meeting. Mashinini, the chairperson of the Independent Electoral Commission.
Good morning, Honorable Chair, Sheikh, and honorable members. As we had discussed, Commissioner Miepia will handle the proceedings, and he will introduce all the delegation from the Electoral Commission. I just wanted to thank the opportunity for us to appear before you, and as already I had apologized, I'm in an international conference as we speak with Indonesia. Thank you, Honorable Chair.
Thank you. We did receive your apology, Chair. Honorable Muepia, if you could maybe introduce yourself and your team.
Good morning, Chairperson, and good morning to the members of the committee. I believe we may be joined, or we are joined by the Honorable Minister of Home Affairs, Dr. Aaron Motsoaledi, the Deputy Minister of Home Affairs, Honorable Mr. Njabulo Mzuza. And I want to thank you for the opportunity, you and the committee. We are joined this morning by the Vice Chairperson of the Electoral Commission, Ms. Janet Love, We are also joined by Dr. Masuku, Nomsa Masuku, a member of the commission. She's with us. The judge may or may not join us, Judge Diapile. The chairperson, as you have heard, may not be with us for the entire session, but the CEO, the Chief Electoral Officer, Mr. Saima Mabolo, and the Deputy Chief Electoral Officer, Mr. Maseko Shiburi, are also online with us. We want to thank you for this opportunity this morning.
Thank you. Thank you very much. From the Department of Home Affairs, Zulani, could you give an indication who is with us, if anybody?
Chairperson, currently we've just got the parliamentary liaison officer, Mr. Makua, present.
No, that's fine. Thank you very much for the introductions, and once again, welcome to this meeting. Honourable members, as I've indicated, that we're meeting with the Independent Electoral Commission to deal with the bill. They'll be briefing us on the Independent Electoral. They'll be briefing us on the Electoral Rules Amendment Bill, B22B 2020, which is a Section 75 bill, and it was referred to the Select Committee on Security and Justice on the 3rd of December. Our members, this bill seeks to amend 3 pieces of legislation, that being the Electoral Commission Act number 51 of 1996, the Electoral Act number 73 of 1998, and the Local Government Municipal Electoral Act number 27 of 2000. And this piece of legislation, this bill, is actually also in preparation for the 2021 local government elections, which honourable members are around the corner. We just thought it prudent that we get the briefing today, so that we can also start dealing with the public consultation processes. Without wasting further time, honourable members, I do have a request from the parliamentary broadcasting team that the meeting is being broadcasted on social media, and they're requesting that members turn on their videos when they speak. Obviously, notwithstanding if you have any connectivity challenges, but be that as it may, let me hand over then to the Commission to take us through the presentation. Commissioner?
Thank you very much, Chairperson. We will be joined shortly by the Chief Electoral Officer. I see on his screen, he's using a machine named Maseko Shiburi. It's actually Saima Mabolo, our Chief Electoral Officer. He will take us through the salient points in the bill. But I need to start the process by indicating that Section 5J of the Electoral Commission Act, Act 73 of 1998, mandates the Electoral Commission to continuously review legislation and propose electoral legislation to make recommendations in that regard to yourselves, and to see that process go through in the lawmaking process. This periodic review is necessary to ensure that our legislative framework for election retains its relevance, its applicability, and validity in our ever-changing electoral landscape. The Electoral Laws Amendment Bill contains amendments, as you have indicated, Chairperson, to the Electoral Commission Act 1996, to the Electoral Act 1998, and to the Local Government Municipal Electoral Act 2000. These amendments are proposed mainly because of the experience we have had, the lessons we have learned, and the consultations we have undertaken following the last elections we held in 2019. We believe it is important that this enhancements and amendments to the electoral process are put or are put into this amendment bill to ensure a smooth management and conduct of our elections. The bill will the salient points, as I indicated, will now be presented by our Chief Electoral Officer, and we will thereafter deal with any difficulties, challenges, questions that the committee may have. I want to thank you, Chairperson, and submit Mr. Mamabolo to you for his presentation. Thank you indeed.
Thank you, Mr. Mamabolo.
Good morning, Chairperson. Good morning, members of the committee, commissioners, and members of staff in Parliament. Zoran, can we move the presentation? Thanks. Chair, this is an amalgam. The bill is an amalgam of amendments to 3 pieces of legislation with a view to effecting technical improvements in the electoral process and to align legislation relating to national and provincial elections. Although next year's election are local government elections, it's important that there is alignment between the electoral scheme for national and provincial, as well as the electoral scheme for municipal election. So in terms of the purpose, in the Electoral Act, we are inserting new definitions. Sorry, in the Electoral Commission Act, we are inserting new definitions. We are amending provisions regarding the registration of parties by providing for registration of political parties at national, provincial, and metropolitan or district levels, while repealing the registration of political parties in respect of particular local municipalities. We streamline provisions regarding the process of applying for the registration of parties, objections against such applications, and appeals against the decisions of the Chief Electoral Officer. And there will be consequential amendments and the repeal of obsolete provisions. In the Electoral Act, we are amending provisions relating to the submission of lists of candidates. We are also amending provisions relating to special votes in the elections of the National Assembly. We are amending the procedure concerning provisional results. And we are providing for the limited applicability of the Electoral Code of Conduct, as well as amend Schedule 3, and we'll get into the details shortly. We are also amending provisions relating to the public's access to the voters' roll, and we are updating references to repealed legislation. And we are also amending provisions related to voters who vote in a voting district in which they are not registered. Zolani? In the Local Government Municipal Electoral Act, we are inserting certain definitions. We are amending requirements for parties to contest elections by way of party list, and specifically dealing with the issue of the acceptance of nomination by voters. We are also providing for a procedure for voters who still do not have an address on a voter's roll to affirm their right to vote whilst complying with the Constitutional Court judgment. We are making amendments relating to the certain effects of certain mistakes and irregularities. And we are making consequential amendments. Zolani? So briefly, the main object of this bill is to enhance existing legislative mechanisms that ensure free and fair elections in order to realize the constitutional imperative as expressed in section 180 of the Constitution. But we are also aligning the Electoral Act with the provisions of the Protection of Personal Information Act, in particular, the protection of personal information of voters against unreasonable disclosure. Now, if we go into each of the clauses, Chair and members of the committee, Clause 1 of the bill relates to the Electoral Commission Act and specifically amends Section 1 of the Electoral Act to insert definitions of the district municipality, local municipality, and metropolitan municipality. And that the definitions that are being inserted are those as apply in the Municipal Structures Act, so that there is consistency as well between those two acts. Clause 2 amends, it's a cleanup amendment. It amends Section 12 of the Electoral Commission Act by substituting Public Finance Management Act of 1999 for the reference to the Exchequer Act of 1975. It's just a cleanup process really there. And Clause 3 is still dealing with the Electoral Commission Act. Clause 3 essentially revises Section 15 of the Electoral Commission Act to amend provisions regarding the registration of parties by providing for parties to be registered at national, provincial, and metropolitan or district levels, while repealing provisions to the registration of parties in respect of particular municipalities, and to streamline provisions regarding the process of applying for and public participation in and applications for the registration of political parties. Let me break it down in this way, Chairperson. Currently, there are only two levels of registration for a political party. It's either you are registered at a national level or at a local, at a municipality level, i.e. local municipality. Now, there are political parties which have a provincial interest, but currently are forced to be registered at national level, even if they don't have an intention to ever participating in the elections of the National Assembly. So they now have to comply with very onerous requirements and the registration fee for an election that they'll never participate. So what we're doing here in the first instance is to maintain the national level of registration, but introduce a provincial level of registration, which will entitle a party registered as such to participate in the provincial elections, but also to contest all elections of municipalities in that province. The second thing we're doing is to introduce either a metropolitan level registration if the municipality is a metro, or a district level. When you are registered in the metro, you may only contest that metro. When you are registered at the district level, you may contest that district municipality as well as its local municipalities. So that's the first import of clause 3. The second import is the following. Any person who intends to register a political party must publish their intention to register together with the acronym of the party, the logo of the party, or the distinguishing symbol of the party. And within 14 days of such publication, those who may be aggrieved by such a registration must then object to the chief electoral officer and say, no, this party represents the values and or what it represents is against the values of the Constitution. There's hate speech in the Constitution of the party, and so on. It's an affront to the constitutional values which we hold dear. Or the acronym already, the proposed acronym already is that of an already registered political party, and so on and so on. So the chief electoral officer, when he considers the registration of that party, must take into account the objections as may be made. Now, then the chief electoral officer registers a party, and then you may still appeal the decision of the chief electoral officer to the commission. What we are introducing here is to limit the people who may appeal. If you did not raise an objection before the chief electoral officer registered the party, you can't raise an appeal. So an appeal is limited to those persons or parties which had already at the first level of the process already raised an objection. This is important so as not to have people having a bite at the cherry continuously without having participated in the initial process. So that's the essence of clause 3. So clause 4, it's a deletion of section 15 capital A of the Commission Act, which provided for the registration of political parties at the municipal level. Is consequential to clause 3. Let's move. Clause 5 still amends the Electoral Commission Act, section 15 thereof, by amending the provisions regarding the publication of the prescribed notice of application for a registration party and the provisions regarding who may appeal. I've dealt with this issue of who may appeal. In order for you to have a jurisdictional capacity to appeal, you must have objected at the initial stage of the application. Clause 6 amends section 23 of the Electoral Commission Act by deleting subsection 3. The import of that is that 23 subsection 3 provided that any regulations pertaining, or rather any regulations that have a financial implication must be approved by the Minister of Finance. Now, that has become a superfluous provision because it predates the introduction of the medium-term expenditure framework, where the Commission's budget is approved by the Minister, who then tables it in Parliament in an appropriation bill, and it's a multi-year approval. So it's no longer necessary, it has become superfluous. If we move on to clause 7, now we get into the Electoral Act. The Electoral Act generally is an act we use for the registration of voters as well as for the management of the elections of the national and provincial legislatures. So clause 7 amends section 1 of the Electoral Act to insert the definition of voting day. So it's a very simple addition there. Clause 8. It's a very important clause. It aligns with two crucial pieces of legislation. One, it aligns with POPIA, the Protection of Personal Information Act. But it also aligns with the PAIA to the extent that it now creates a situation where there's a uniform framework for access to information held by the state organ, ourselves as the Electoral Commission, and do not have multiple frameworks that sometimes prove to be contradictory. So firstly, clause 8 revises section 16 by removing the existing entitlement of any person, and our emphasis, Chair and members of the committee, the entitlement of any person to a copy of or an extract of the voter's roll. So currently what we're trying to cure, any person on a payment of a prescribed fee can apply, and upon such application, the Chief Electoral Officer must provide a copy or an extract of the voter's roll to that person, anybody. Now, the voter's roll bears sensitive personal information of voters, i.e., the full ID number, full names of the voter, as well as the address of a voter. Now, that flies against the stated objectives of POPIA, where there's unreasonable disclosure of the private information of voters. But this removal does not mean no one will ever get a copy of the voter's roll if there's a matter of public interest. Because then PAIA comes in. PAIA sets out a common national framework for accessing data held by state institutions, including the IEC. And PAIA balances the right to freedom of expression on the one hand, as well as the right to the protection of personal information. So by removing this section 16.2, we're allowing one common national framework for accessing information of voters. So that's one issue that we are dealing with in clause 8. The second issue we are dealing with, clause 8, is an introduction of section 16.5, which will authorize the Chief Electoral Officer to redact any information from the voter's roll made available to parties and candidates to protect personal information of voters against unreasonable disclosure. Political parties and candidates contesting an election are entitled a copy of the voter's roll for two purposes: to canvass for votes on the one hand, but secondly, to ensure that the voter's roll it's a correct reflection of how people are registered and whether people are registered in the correct segment. So both of those objectives are cumulatively work towards the realization of the constitutional imperative of a free and fair election. Nonetheless, the intention is to redact some information from the ID number. And the intention is to redact the middle section of the ID number without interfering with the birth date. The relevance of the birth date is that political parties must be able to see that the voter is qualified in terms of the constitution, in terms of eligibility criteria, which includes age. So we're not going to redact the date of birth rather. We're going to redact the middle section. We're not going to deal also with the last 3 digits, which indicate citizenship or otherwise of the voter, because those deal with the eligibility. So this amendment seeks to harmonize the Electoral Act with the provisions of OPIA. We can move, Zolan. Clause 9 revises Section 24A of the Electoral Act to allow a voter who is unable on voting day to cast a vote in the voting district where she is registered to cast a vote in another voting district, provided that she notifies the Chief Electoral Officer in the prescribed manner of his intention to cast her vote in another specified voting station within the Republic on voting day. Currently, Chair, there's a very dangerous phenomenon which is beginning to undermine and erode the credibility of our voting process. That is, on election day, any person goes to any voting station. People, in fact, shop for shorter queues. If you are registered in one station, you find that there's a queue there. You just drive around to go find a shorter queue. Now, here is the problem. Logistical provisions to voting stations are made in accordance with the number of registered voters. So if a station has 600 people registered, the logistical provisioning will accord with supplies to meet the demand of 600 people. And accordingly, if it's 3,000 people, the supplies will meet the demand. Now, the shopping for queues undermines the integrity of the logistical plan. And hence, you hear on election day that ballot paper are finished, there are no VEC4 forms on those types of things. So that it's undesirable in an orderly conduct of voting. The second issue is this breeds the ground for people saying, no, I've voted twice because I've been to the station and I've been to the other station. And with the pervasive use of social media, this can be undermining to the integrity of the process. Now, we do not think it would be fair to repeal this provision, but we need to enrich it. And the proposition for the enrichment is that the facility remains available. However, it can be accessed via pre-notification by a date which will be prescribed in the election timetable. So if you know that you're going to be driving, you are a truck driver, you're going to be en route to Cape Town, By a date, you need to say, I won't be able to vote at my voting station. I'll be able to vote en route in Bloemfontein at this particular voting station. Then we are able to take the necessary supplies to that voting station. 1, 2, we are able to share with political parties to say, so many people are going to be voting outside of their voting stations. And the lists are available. The oversight responsibility of political parties and the media is strengthened by so doing. Clause 10. Clause 10 amends Section 27 of the Electoral Act in order to dispense with the requirement for parties to submit a prescribed notice of acceptance of nomination together with a party list, but to instead require parties to submit the notice of nomination to the Commission upon request in the prescribed manner. We've moved largely, of course the modalities are two, but largely we've moved to a electronic nomination of candidates. It happens online. And so on. Proving and back is not to present the acceptance of nomination in respect of a candidate or candidates, and for that party will be given a few days to submit that. So you're not going to submit it ordinarily in the ordinary course, but should the Commission require it, you need to submit it within a particular time. Clause 11 are just consequential amendments as a result of clause 10. Similarly, clause 12, those are technical amendments to section 30, which really arise out of clause 10 as well. So clause 13, clause 13 amends section 33, and this deals with special votes for persons. Let's just say special votes for the election of the National Assembly. So clause 13 amends section 33 of the Electoral Act by removing the requirements for voters who will be abroad on voting day to apply for a special vote, and instead require such a person whose name appears on a segment of the voters' roll, who are in the Republic, to notify the Chief Electoral Officer in the prescribed manner by a date stated in the timetable. This first category, it's if you are registered in the voters' roll inside the Republic at one of the 23,000 voting stations, but you're going to be overseas on voting day, you then need to notify the Chief Electoral Officer of your intention to vote and the mission at which you intend to vote. So we retain that we retain that scheme. Let's move on to the next one. Now, the second category is a person who is ordinarily resident at a place outside the Republic and intends to vote at the South African High Commission Embassy, and on whose segment of the voters' roll his name appears, to simply present himself or herself to vote at that embassy. This means if you are registered on the segment of the voters' roll, the international segment of the voters' roll in the South African House in London, you do not need to notify us of your intention to vote there. It's a superfluous requirement because you are already registered on that segment in London. So we assume that you're going to vote there because that's where you are registered. The third category is persons who are registered on the international segment of the voters roll. And a person, again, as an example, you are registered in London. However, you want to go on voting day, on special voting day, you'll be in Canberra, Australia. In that case, you are then required to notify the Chief Electoral Officer of your intention to vote in Canberra so that arrangements can be made for you in Canberra. So that's what the, clause 13 is dealing with. Clause 14 proposes to authorize the Commission to prescribe the form that is required to be completed at the conclusion of counting. Essentially, that form bears the ballot reconciliation statement and says at that voting station how many ballots were received, how many were used, how many were cancelled, and how many remain. And it's important that there's a reconciliation. Now, currently, Section 50 bears all those requirements, but the Commission is of the view it's best to deal with that in the regulation so that if there are changes that need to be made, we don't have to go through a extensive parliamentary procedure. Rather, we could consult with the PLC, with political parties in the PLC and work it out in the regulations. Clause 15 amends Section 99 of the Electoral Act to insert a new Section 1 capital A, which provides that the code is binding from the date on which the notice calling an election is published to the date on which the result of the election is declared. The import here is that the Electoral Code in some respects has the effect of limiting certain rights of people. And as such, it has to have a limited applicability period. And that it is not ever present within our public space. So in order to make it clear, we are introducing this Section 99(1) capital A to indicate that the code is applicable from the date on which an election is called to the date on which the results are declared. Because in any event, Chair, until an election is called, there's no election. An election arises on the date on which it is properly and lawfully proclaimed. So we're making it clearer by introducing this 99(1) capital A. And then 16, Clause 16 amends Schedule 3 of the Electoral Act to require the Commission to complete and publish the determination of seats of the National Assembly and all provincial legislators ahead of every election. Chair, the Schedule 3 currently has a date on which the Commission must determine the size of provincial legislatures. So currently, and that date is 31 March 1999. And since 1999, there's been significant movements in population across the 9 provinces. So the sizes of our legislatures, provincial legislatures, have stagnated and are not responsive to the changing demographic distribution, in fact, the population distribution. So what this section introduces, we are conscious that in terms of the National Assembly, we've reached the maximum point, which is 400. So there's no need to be dealing with that at any election. However, in terms of provinces, the Constitution provides for a minimum of 30, a maximum of 80. However, there are provinces that have gained significantly in population sizes, yet the size of the legislature has stagnated since 1999. So this proposal will authorize the Commission to make a determination ahead of each election of a provincial legislature. And that then concludes amendments to the Electoral Act, and we now turn to amendments to the Local Government Municipal Electoral Act. And we start at clause 17, which amends section 1 to insert the definition of district municipality and to delete the obsolete definition of a district management area. Again, that definition will accord with the definition in the Municipal Structures Act. Clause 18. This is a twin clause to one we dealt with earlier, and it's intended to dispense with the requirement for parties to submit the prescribed notice of acceptance. The same principles will apply in respect of local government election, where candidates who are on a party list don't have to submit the list of candidates, the acceptance of nomination. However, should the Commission require it within a defined period, the parties must submit same. And clause 19 also dispenses with the requirement for candidates in ward elections to submit an acceptance of nomination. Is the same principle applies. Clause 18 deals with PR elections, and clause 19 deals with ward elections, but the same principle. Clause 20. Now, clause 20 is a very important clause, and perhaps I must give this background. In 2016, when the address matter was before the Constitutional Court, at that point, we had 8.6 million complete addresses of voters out of 24 million people who were then registered. At the moment, there are 24.6 million South Africans who are on the voters roll, and we have a complete address for them. So there's been a significant improvement in the acquisition of addresses on the voters roll. So 95% of voters on the voters roll today have a complete address. But there's a residual 1.2 million persons for whom we still do not have an address. Our position is that such persons do not lose their right to vote. But we still need to comply with the requirements of the decision of the Concord in the Mhlophe matter. And to that extent, we are proposing a slightly varied voting procedure for voters without addresses. And that will entail them supplying an address before they're given the ballots. And a determination will have to be made by the presiding officer as to whether the given address places that voter in the correct ward. And if it doesn't, then he or she can't vote in the ward election. She will only vote in the PR election. So we already have a similar provision for national and provincial elections. So we are introducing it for local government. And then clause 21 amends section 84 of the Municipal Electoral Act to make it clear that a mistake in a certified segment of the voter's roll does not invalidate that segment of the roll. This proposal mirrors section 99 of the Electoral Act as well, to clarify that the code is binding from the date on which the notice calling an election is published to the date on which the result is declared. Clause 22, I think clause 22 deals with the application period of the code of conduct, and clause 23 is the last clause that provides the short title and the procedure for the commencement of the act. Chairperson and members of the committee, that is the Electoral Laws Amendment Bill. Thank you.
Thank you. Thank you very much, Mr. Mamabolo. Commissioner Muyapiat, is there anything you would like to add?
Yes, thank you very much indeed. I would like to indicate that for its part, the Commission has held consultative processes with the Party Liaison Committee in the national sphere of government. We've also engaged with the information regulator in respect of the provisions relating to clause 8 that the Chief Electoral Officer extensively took the time to explain. We finally had consultations with the Portfolio Committee, given the publication of the, that invited comments on the bill. And to that extent, we have responded to over 12,000 submissions, mainly submitted via the Dear South Africa website. We had a further 28 submissions submitted through other stakeholders. This is the road traveled by this bill. And today, Chairperson, we sit before you on the same bill, and we will gladly clarify any questions members may have. We'll take counsel that you may want to offer on the matter, and so we want to submit this process into your hands. Thank you very much indeed.
Thank you very much, Commissioner and the CEO, for this elaborate and comprehensive presentation. And I just think that in addition to the amendments that relate to the alignment of issues as well as technical corrections in the poll, I think as we in this committee, we are members from various provinces, and we also represent different political parties. And I can also confirm that we have also experienced in terms of some of the gaps that this amendment bill is trying to address. Having said that, honorable members, I'm going to open it up for yourselves if you have any questions of clarity on what has been presented, or if you even have any comment on what has been presented. Honorable members, if you can maybe give an indication on the raise your hand function. Okay, I'm noting Honorable Mtetwa and Honorable Ndogo also has his hand raised up. Those are the two for now. Let me start with you, Honorable Mtetwa. Honorable Zanamela, you noted. Honorable Mtetwa.
Thank you very much, Chair. I'm not sure whether I'm audible enough.
You are, please continue.
Yes, Chair. Mine, Chair, is to get more information regarding the safeguarding of the data. Now that you know these days people, how they deal with data. So that's my concern, Chair, when this data is going to be given to anyone. How sure that the citizen is more safe on that, and how, because people can do anything with that as well. And secondly, in terms of the NCOP, will there be any changes as well in the numbers in the NCOP? Thank you very much, Chair.
Thank you, Honorable Mtetwa. Honorable Dodovu.
Thank you, Honorable Chair, Honorable Faith. I want to ask a question in a general way, and that relates to these amendments to the Electoral Act. How do they respond to the constitutional judgment? I hear the presenter talking about an extent in which the issue of the addresses of voters has been addressed, and which is quite good. But the truth of the matter is that in the CAM case at the Constitutional Court, the IEC was badly exposed, especially with regard to the issue of securing sufficient particulars for voters, ensuring that addresses are there, and all of that. Now, I became extremely worried because where I am in the Northwest, I'm just 40 kilometers from Tlokwe, where all of these things happen, and I have a background and history to all of these particular issues. Now, my question is, to what an extent does this amendment respond to that judgment, the CAM judgment at the Constitutional Court? Because where I sit, I don't want to see all those problems obtained, recurring, and in that the IEC was, the Concord indicated to the IEC that what you are doing doesn't wholly satisfy the requirements of Section 190 of our Constitution, of ensuring free and fair elections, of ensuring that voters, in a sense, are protected, and if the credibility of the elections are questioned, that speaks to the heart of what we stand for as a country. And my question, as I indicated, is to what an extent does this amendment relate and speak to the CAM Concord judgment? Thank you, Chair.
Thank you, Honorable Dodovu. Honorable Seleku.
Good morning, Chair. Good morning to all members and to the Commission. Chair, let us go to Clause 8. And I hear what the presenter has been saying, that ample consultation has been underwent. And I would like the presenter to share just with the select committee in terms of the views of other political parties when it comes to that particular section, which is Section 8. And also, Chair, if you look in terms of the submissions that we received, written submissions, which is about 12,000, I think the majority of those submissions dealt basically with Section 14 and 21, which in the end was omitted, was because it dealt with e-voting, and then there was a consensus reached saying that we shouldn't go that because we're not ready as a country for that particular exercise. So also what is important, Chair, is that I'm very worried when it comes to public participation, because anything that might actually subject our elections to be doubted, or we might lose our credibility of free and fair, we should not be rushing, and we should actually hear all views. If there is an outcry outside, from each and every member specifically when it comes to a particular clause, and there is threats or there is promises of saying that if you don't listen to our views, we might take the following process of maybe challenging it to court, and then it will become a problem. So we should actually just get more information in terms of the views, when it comes to clause 8. And Chair, the second one is that I would like to know from the Commission, from the IEC, in terms of timeframes, how pushed for time are they for this bill to be passed? By when should they actually conclude all these processes? And also in terms of the 15 days for people overseas to apply, is it sufficient? Do they think that that is sufficient? And how did they come to 15 days? And also, Chair, they also need to, in terms of the information that will be omitted, when a person applies for a voter's roll, the presenter only mentioned a section of the ID. Is that the only information that the Chief Electoral Commissioner is allowed to hide or censor when such a request is made, or is there more that the Chief Electoral Officer might actually, hide from the voters' roll? Because we all know, the voters' roll does actually assist some of us in a lot of ways. We know the history about people being bussed to certain districts, to certain VDs, and as a result, because of access that each and every individual had to gain access to the voters' roll, we are able to detect some information that has actually led to some people that were trying to do things that were irregular and making sure that certain organization or certain parties win elections. So when such is omitted, or when such is no longer going to be allowed, how are we going to make sure that there is transparency and that those that are supposed to be voting in that particular VD and ward are actually legitimate people, and we can actually say after an election, it was indeed free and fair, and there was nothing hidden. All those that voted in that particular ward is actually residents of that particular ward. Thank you very much, Chair.
Thank you, Honorable Seleku. Honorable Dango.
Yes, Chairperson. Chairperson, my question is really where the determination by the electoral officer at the point when a person is voting with no address to place them in a particular ward. Is that subject to the party agents or agents present there to object to such a determination? Thank you.
Thank you, Honorable Dango. Honorable Zandamela. Honorable Zandamela.
Thank you, Chair. Thanks, Chair. Mine, it's only 2 questions or clarity-seeking questions. It's on the registration of political parties. They in the presentation they mentioned that or individuals, they can register, or let me rather say political parties can register for only local metro district. And well, they gave clarity with regard to if you've registered for district elections, you can also participate in the local elections. I didn't get them clear when it comes to the province. If it's either when you've registered to participate at the provincial level, you automatically be allowed to also participate in the district and the local council. That's the first one. And the second one, it's about, I can't remember the slide, but it was about, that has to do with if you indicate not being able to vote where you are registered, like I think they mentioned also the issue of the truck drivers and all those kind of things. But my question there is, we know what's happening with elections. How are they going to, because normally in a voting station, if there's 3,000 people registered in that voting station, I'm not sure, I stand to be corrected with regard to the printing of the voters' roll. Do they print, how are they going to control that? We know the issue of rigging and all those kind of things. If I now, for instance, say I'm not going to be able to vote, to register where I've voted, so how are they going to control it? What mechanism is there to avoid rigging? Thanks, Chair.
Thank you, Honorable Zandamela. Is there any other member who is unable to use the raise your hand function and would still want to make a contribution or ask a question of clarity? Okay, if there's none other, I think just from my side, and I think members have also raised it, but I do think that the protection of personal information of voters against unreasonable disclosure is an important aspect, and I'm glad that we're making progress, especially in terms of aligning this piece of legislation with the Protection of Personal Information Act. And clearly the fact that PAIA is also available in terms of access to information. I think the framework, the legal framework around that does provide some kind of protection. I think all members have asked other relevant questions in terms of clause 8, but just in terms of clause 9, and that is when a voter who is unable to, on voting day, cast their vote in a voting district where they registered. The procedure that is being put in place by the amendment to this piece of legislation, is it sufficient to ensure that a person will not be able to vote twice or more? I think those are that was my question and my broader comment. Let me just ask members once again before I hand over to the Commission, just so that I don't leave anybody else out. Okay, I don't see any other member. Let me then hand over to yourself, Commissioner, to deal with the questions. Thank you.
And Chairperson, I'd like the Chief Electoral Officer or his nominee to respond to the questions, and then I will ask members of the Commission. There's Vice Chairperson of the Commission online. There's Dr. Masuku. If there's anything, and then I will deal with any matters that are outstanding, if you so permit, Chairperson.
Yes. Mr. Mamabolo.
Thank you, Chairperson and Commissioner Miepsha. The issue that Honorable Untitled raises is exactly what we are trying to do in terms of amendments to clause to section 16 of the Electoral Act. We are trying to align the Electoral Act with the provisions of the Protection of Personal Information Act to minimize the unreasonable disclosure of the personal information of voters. So that the principles that are embedded in PAIA also apply in respect of the voters' roll. And those principles inter alia include whether there is a public interest in such disclosure of personal information. And to balance the protection of personal information on the one hand, as well as the freedom for freedom of free expression and so on. So what we are trying to do is exactly to minimize the unreasonable disclosure of the personal details of voters. Currently, any person can ask for a voter's roll for as long as they paid a prescribed fee. And we're saying that can be, because the personal information of voters is crucial. It has sensitive elements, and we want to protect that. However, I think, and I want to emphasize this, we're not taking away the right to access of information, but there's a procedure that is that operates on a principle of public interest, which is embedded in PAIA. And if the threshold of public interest is met, there will be limited disclosure in respect of that class of voters or that one voter. But you can't make an application and say, I want the records of 26 million people who are on the voters roll. So that's the first issue that I wanted to address. The second issue that Honorable Mthethwa raises is in respect of the size of the National Council of Provinces. This is a matter that is dealt with in the Constitution, and the size of the NCOP is determined in the Constitution, and thus the Commission cannot avail an opportunity to itself to determine otherwise. So the short answer, therefore, is that we are constrained from dealing with the size of the NCOP to the extent that is constitutionally determined. The general issue that Honorable Dodovu raises regarding the CAM judgment. We are not at a perfect point vis-a-vis the addresses on the voters' roll. But it's an undeniable fact that significant progress has been made. Like I indicated, in 2016, the people who did not have addresses on the voters' roll were 6 million. Today, that number has been reduced to 1.2 million. So, given the CAM judgment, the country has spared no effort, and basically we broke the bank to ensure that we ameliorate the weaknesses that the Concord had identified. Hence, this improvement that we've made over the course of the last 4 years. Will we ever reach 100% wall-to-wall coverage of addresses? Probably not, given uneven development in the country. Still, a significant number of South Africans live in rural areas where conventional addresses don't obtain. And on a daily basis, a significant number of South Africans are establishing informal settlements, which don't have addresses and those types of things. But to the maximum extent possible, the Commission will collect addresses and place them in the voters' roll. Addresses or sufficient particulars of a person's place of residence. So, Honorable Dodovu, we're working at the matter. We are not where we want to be, but we've made significant progress in the last 4 years. And then the questions that Honorable Seleku raises. Clause 8 has its genesis in a workshop held between the Electoral Commission, the Information Regulator, and political parties at the beginning of this year. So that's where the consultation started with the information regulator and parties participating in the political liaison committee. And in that workshop that we held, there was consensus that we've got to do something about Section 16, because as it currently stands, it opens up the commission to the unlawful disclosure of personal information of voters in violation of POPIA. But the consultation did not stop there. In the PLC itself, political parties were continuously updated and continuously consulted on the various iteration of the bill as it was processed. So political parties in the PLC are part of the journey of the evolution of this bill. They're part of that journey. In the National Assembly, there was public submissions that were invited by the committee, and an issue with Clause 8 was not raised by a substantial number of submissions. It was raised by an institute that works within the media space and so on. The substantial submissions related to Clause 14 and 21, the erstwhile 14 and 21, which were subsequently removed from the bill by the portfolio committee. So those are not part of our discussions today. The select committee obviously needs to do a public participation process, and you'll define the nature and of that public participation process in terms of the applicable rules. But we cannot at the very beginning say there's no public participation. We can fashion public participation going forward. Now, the time, this bill is required to make preparations for the local government elections. Now, constitutionally, they have to be held according to a particular time frame, and that is the 4th of August, between the 4th of August and the 1st of November, an election must be held. But an election must be held on a basis of a clear, determined legislative framework, which must include these amendments. Staff have to be trained on some of these provisions, so manuals must be updated. Training manuals must be updated. National training workshops must be conducted. Provincial training workshops must be conducted. And for registration weekend, close to 60,000 people must be trained on the basis of some of the amendments that are in this bill. So the quality of the training that is given to the staff is inextricably linked to the passing of this bill. So ordinarily, the legislative framework for an election has to be determined and settled a year ahead of an election in normal circumstances. But here we've been hindered by the COVID pandemic, and we've not been able at all levels, in the commission, in the executive, and so on. We've not been able to move at the speed that we would ordinarily have had it not been for COVID. So we are in a situation as a result. So we believe that the bill must be on hand towards the end of February, being the outer point. Now, the last question that the honorable member raises is the 50 days, how was it determined and so on. The current scheme, the law as it presently applies, any person who intends to vote outside of the country must notify the Chief Electoral Officer 15 days after the proclamation of the election. Whether you are in South Africa going overseas or whether you are already registered overseas, you still need to notify the Chief Electoral Officer. So that is a presently, that provision currently obtains. What we are proposing is to lessen the burden, remove some of the onerous requirements. If you are registered in London and you are on the segment of the voters' roll in London, we're removing the requirement for you to notify us because we are already registered there. So we assume you're going to vote there. If, however, you are registered in London but want to vote in Washington, you have to notify us by a date stated in the timetable. So we're removing the requirement of the 15 days, and we hope that will give more days than the 15. Similarly, if you are registered in South Africa, you intend voting outside of the country, you have to notify us by a date, which will hopefully be greater than the current 15 days. And then the issue that Honorable Dengo raises about whether the determination of the presiding officer will include an opportunity for party agents to observe the determination and whether they'll have an opportunity for objecting if necessary. Yes, there will be that opportunity. It will be prescribed in the regulations, and there'll be a form for such objections to be made. And that is a mirror image of what already obtains in respect of national and provincial elections. Now, I didn't quite get the honorable member's surname, so my apologies for that. The Chair?
Zandamela, Honorable Zandamela.
Oh, Zandamela, thank you very much, Chairperson. The registration levels, we are streamlining it. Currently, you could only register at national and municipal level. Now, like I indicated, if you are registered at municipal level, you may only contest that municipality. Even when your party grows in that province, you can't contest other municipalities in that province unless you go register in each of the municipalities individually. Now that's it's not smart. There's a reality that some of our political parties have a strong provincial presence, and we need to accommodate a registration level at the provincial level without forcing them to register at national in circumstances where they don't have a national interest nor a national footprint. So registration levels will be a national registration which entitles you to contest everything in the country. A provincial registration which entitles you to contest everything in the province, and a district registration level which entitles you to contest that district and all municipalities in that district. Now, the issue of Section 24A and how we're going to ensure that it is not abused, it is precisely the point that we are ameliorating. Currently, during national and this provision is only applicable during national and provincial elections. It's not available in local government elections. But currently, you could go to any station. If that station is within your province, you get 2 ballots on signing a VEC4 form, which is a sworn statement. And that has been abused. And the extent of the abuse is such that it's beginning to erode the credibility of the process. Hence, we're asking Parliament to intervene to sustain the credibility of our electoral processes by ensuring that this facility remains available, but it remains available upon pre-notification by a date to be stated in the election timetable. Then the notification list will then be availed to all political parties to allow them to exercise oversight over the process. It will be given to party agents to ensure that they are able to observe the process, and that it's limited to only persons that had pre-notified and who are on the pre-notification lists. That, in our view, is increasing the oversight envelope and minimizing the occurrence of electoral fraud. So it's an important intervention that we're asking Parliament to make in the interest of the credibility, retaining and preserving the credibility of the process. And then lastly, Chair, the point that you raised on the protection of personal information. I think, to reiterate, Section 16.2 predates both Bahia and Poppy. It's an antiquated provision which stands to be repealed, so that the provision access to the voters' roll is retained, utilizing a generally used scheme of access to information which is embodied in Bahia. The right to access to the voters' roll is not being taken away. It's been delegated to the it's been remitted rather to the law that deals with public access to information held by the state. In that act, there are certain principles that must be observed, which take into account the public interest matter. Chair, I think I've tried to address the questions. I'll hand over to the commissioners. Thank you very much.
You, Chairperson. I just want to check Commissioner Love, Commissioner Masuku, the Chairperson, if there's anything that we have omitted. Let's make that contribution. I'm aware that we are now in extra time. We have exceeded the time that was set for this occasion. But it is important that we make submissions or clarify any position that there may be. Thank you.
Through the chair, I have nothing further to add. Thank you.
Thanks, Commissioner Apia. I think that the questions that have been raised have been covered well by the CEO, and I think that the point that he and you also have emphasized to the honourable members is the fact that for us as the Commission, every election brings with it experience and opportunities for improvements. And that's, I think, what we're bringing to Parliament to say, these are things that over time, things have changed, patterns of behavior have changed. We want to work with you as members of Parliament to make sure that we're improving things. And I think that that's what this legislation is intended for and what it's about. I think that, Commissioner, you should talk to the issue of time. One of the honourable members did raise this quite specifically, and I think you're in the best place to do that. Thanks.
Chairperson, we submit this to you. I do not have anything further to add. I think the Chief Electoral Officer has dealt with all the matters. You asked a question in relation to Clause 9, and you were asking whether the procedure would be good enough for us to deal with matters that are arising in relation to that Clause 9. I want to assure you, as the Chief Electoral Officer was addressing this matter elsewhere, that after this bill has been passed into law, we need to draft regulations, which we consult with parties represented in the national sphere of government, the Party Liaison Committee, and then we will pass those regulations. We'll deal with those extensively. Safe to say that so far, everything concerning voters that don't have addresses on the voters' roll has been dealt with very successfully, in that when they come on election day, we do take their addresses, their particulars, and party agents engage. A case in point, in the last by-election held in November, we had parties joining us as we went to verify addresses of certain voters, and that process did in fact meet the requirements of all parties concerned and the voters affected. I thank you very much indeed for this opportunity.
Thank you very much, Commissioners and the CEO. Honourable members, if you have a burning issue, I'll allow you to raise it. But I'd also want you to note that this is the beginning of our process. We're still going to embark on a public consultation process, as well as engage further in terms of the details of this call. So I'll allow you, if you have a burning issue, to raise it. Honourable members.
Honourable Chairperson.
Honourable Fayela.
Yes, ma'am. My concern is not a question per se. I don't want to pose it as a question. I just want to comment, like, you see, our IEC in South Africa, if you look the way they do their job compared to other election commission in Africa as a whole, is a better one. Our IEC is a better IEC compared to other countries. But I want to comment by saying the issue of training, Madam Chairperson, is very important. Their guidelines as IEC is clear, straightforward, and I really like it. But their staff at the polling station are the ones that let down the IEC. Because once they have guidelines, their staff needs to stick on the guidelines, not divert it. So they end up becoming a very havoc at the polling station because of their staff at the polling station. So I want to say, Madam Chair, the issue of training, we need to make sure that their training become very intensive and their staff become really, really very, very, very neutral in the polling station and not divert any guidelines that are put before them. Thank you, Madam Chair.
Thank you, Honorable Mkayela. That was a comment. Let me once again maybe just also thank the Commission for the presentation, but also to remind honourable members that ensuring adequate participation is our responsibility. And while we understand the need for us to work more efficiently in terms of this bill, and despite this time frame, I think we should also make it clear that we will not compromise any of the procedures that are required to ensure that there's public participation. And honourable members, just to indicate that given that we're also going to through a festive period, we will be advertising the bill for public comment. We'll actually advertise it as soon as we can, possibly in this week. But the indications are that we would give the public sufficient time and until the 22nd of January 2021 to make the necessary submissions that they need to make. And we're doing this bearing in mind that we have a festive period that kind of comes in between this time frame. But as I also indicated, that we will ensure that due process is followed. So once we receive the necessary submissions, I would imagine that towards the end of January, if everything is in place, we will then convene a meeting of the committee to then look at the submissions and to also agree on the process as we move forward. That being said, from the side of the Select Committee, thank you very much, Commissioner Moaeka, Commissioner Love, and Commissioner Masuku, as well as the CEO of the Independent Electoral Commission for the briefing and providing the clarity that members required. And I can imagine this is not the last time we would be meeting with you, but we would be moving along this journey together towards the logical conclusion of this piece of legislation. I can release members of the Independent Electoral Commission and staff, and honourable members will then continue with the minutes of the committee. You'll recall that we have 7 sets of minutes that we need to deal with, which we've been deferring over the past few meetings. And that has been because while we were busy processing the other pieces of legislation, at times we didn't have the necessary time to do it, or members had received copies of the minutes rather late. I'm not sure Gershwin or Zolani who's going to be projecting the minutes, but if we can start with the minutes of the 2nd of September 2020, and I should apologize to honourable members. I'm not sure how this set of minutes actually fell through the cracks. You'll recall that in October we've also been adopting minutes, but be that as it may, it seems that when we look back at our minutes, we realized that the minutes of the 2nd of September was not adopted by the committee. Zolani or Gershwin, who's assisting us?
I am Chair. Zolani.
Okay, I don't know if it's just myself, but all members, can you see the document? I just see the open file screen.
No document, Chair.
Yes, please, Zolani.
Chair, let me ask Gershwin to project, because on my side is projecting the 2nd of September.
We have not opened it. Open the file.
Yes. Right, there we go. Okay, thank you very much. Honourable members, on the the meeting that we held on the 2nd of September, it's quite an old meeting, but we dealt with the committee report on the prescription in civil and criminal matters amendment bill. as well as the report on the provisional suspension of office of Ms. K. Butlani. And I think at that meeting, we considered minutes as well. But just in terms of attendance of that meeting, I think we received apologies from Honorable Dango, Honorable Mpayela, Honorable Bartlett. And at that time, Honorable Maleka was representing, was also an alternate representative from Mpumalanga who was attending our meetings, but she had also given us an apology. Our members, I'll maybe call for if there were any amendments that you picked up that you would, or corrections that you would want to make to these minutes. It was a very procedural meeting, if I may put it that way, where we dealt with the adoption of the two committee reports. If there are no amendments that you would like to make, perhaps then if there's anyone who would then want to move for the adoption of these minutes. Honorable Mteto, I see your hand is still raised. Is it still raised or are you raising your hand?
It's Dodovu.
Honorable Dodovu.
Yeah, I move for the adoption of the minutes.
Thank you, Honorable Dodovu. Can I get a seconder, please?
Mteto, Chair.
Thank you,
Mteto,
Honorable.
Chair.
Thank you very much.
Chair, I wanted to raise that I raised with you that day that I was having a network problem. It's not necessarily absent. I phoned you direct actually when I was having a network problem.
In that
I
meeting.
was taken off.
Okay. I don't think.
On the magistrate.
I think your attendance has been registered to that meeting, Honorable Mteto.
It's registered absent, Chair.
Is it?
Yes, Chair.
No, we'll correct that then, honorable members. I have the screen open at the moment, but maybe then let's go to the minutes of the 4th of October 2020. Gershwin? Gershwin or Zolani, if we can get the minutes.
Hi, Chair, just give me a second. Chairperson, I've got 14 October.
Is it 14th of October? Okay, then it is the 14th of October. Did I say the 4th? Apologies. Our members, while Gershwin is putting that up, in terms of this meeting, we dealt with, we received a briefing in that meeting from the Department of International Relations and Cooperation. They gave us a briefing on processes followed for the ratification of bilateral and multilateral agreements. And they also focused on the nature and coordination of city twinning agreements with foreign provinces, legislatures, and municipalities. And I think in terms of this meeting, Honorable Motsamai, Honorable Dodovo, and Honorable Fisser were not in the meeting. You may scroll down, please, Gershwin. And if you can just go to the recommendations. Yeah, I think that one of the issues that did come up in that meeting was around the assessment that the National Department of International Relations is doing in terms of the twinning agreements between provinces, municipalities, and other countries. And I think this is what we had said in that meeting, is that we should be provided the report of the assessments of such benefits. Honourable members, if you have any corrections to make to the minutes, please indicate so, or if not, also indicate if you would want to move it for adoption. All members?
I move the adoption of the meeting.
Okay, I have Honorable Tetwa has moved for the adoption. I hear Honorable Bartlett.
Chairperson.
Second, Chair.
Thank you, Honorable Bartlett. I've also heard you, Honorable Kosi, but thanks. I have a move and a second. If you can
No,
just
it's
move.
fine, Chair. I wanted to second.
Thank you, ma'am. Okay, we'll move then to the next set of minutes, which is dated the 3rd of November 2020. And I think in that meeting we dealt with the C list of amendments for the traditional courts bill, and we also adopted minutes of the 21st of October 2020. In terms of attendance, I think we received an apology from Honorable Dango. Other than that, all members were present. Yeah, honourable members, I think this was a very, the minutes are quite short also in this matter because it deals with the procedural issue around the consideration and adoption of the C list of amendments. If there's no correction that any member would like to make, if I can get a member to move for the adoption of the minutes and
okay.
Yeah. Nkosi?
Chairperson?
Yes, Honourable Nkosi.
Yeah, thank you very much. I move for the adoption of the minutes as true reflection. Thank you.
Thank you. Get a seconder. Is that you, Honourable Dodogo?
Yes, I do. I do second.
Thank you, Honourable Dodogo. We'll then move to the minutes of the 10th of November 2020. And members, my apologies for putting you through this, but it is inevitable that we adopt these minutes at some point. I prefer that we don't take it into the next year. The minutes dated the 10th of November 2020, in that meeting, we received a presentation on the negotiating mandates of the Recognition of Customary Marriages Amendment Bill, as well as the we received a briefing by the department in terms of their responses to issues raised in the negotiating mandates, as well as an input by our parliamentary legal advisor. And the committee deliberated on these matters. In that meeting, we received apologies from Honorable Nita, Honorable Rakis, Honorable Dango, and Honorable Mtetwa. Yeah, I think I said it earlier that a lot of our meetings dealing with, a lot of our minutes are dealing with procedural matters. And members, if there's any addition or correction you want to make to the minutes, please do. If not, if you're ready to adopt the minutes, please indicate that too. Honorable Bartlett.
I move, Chair. Sorry.
Thank you, Honorable Bartlett. I understand that your signal is not too good, but you've moved. Can I second, please?
Hi, good to hear your voice.
Yes, how are you?
Honorable Dodogo. Honorable members, can I get a seconder for the minutes, please?
I second that, Chair.
Okay, I got a seconder. I didn't pick up who said that.
The Honorable Mutamai.
Honorable Mutamai. Oh, thank you very much, Honorable Mutamai. Honorable members, we'll then move on to the minutes of the 18th of November 2020. This meeting, we dealt with the A list of amendments for the Recognition of Customary Marriages Amendment Bill. We also dealt with we considered the final mandates on the Traditional Courts Bill, and we considered that bill on that day as well. In terms of apologies, we received an apology from Honorable Fisser and Honorable Dango. Honorable members, again, we dealt with procedural matters in that meeting. If you have any addition to make, please do so, or correction. If not, if we can then get a mover for the adoption of the minutes. Our members, can I get a mover for the adoption of the minutes if there is no correction?
Chair. Thank you very much, Chairperson. I so move the minutes.
Thank you, Honorable Nkosi. Can I get a second, please?
I second that, Chair.
Honorable Matsamai, thank you very much. Thank you, members. The minutes are duly adopted. We can then move to the meeting of the 25th of November. In terms of that meeting, honorable members, we considered the traditional courts bill, as well as the final mandates on the recognition of customary marriages amendment bill. We also dealt with the adoption of the recognition of customary marriages amendment bill. And I think in terms of the adoption of outstanding committee minutes, that was also deferred. In terms of that meeting, the apologies we received was from Honorable Nita, Honorable Dango, and Honorable Mfayela. Am I correct? Yes. Yeah, our members, is there any amendment that members would like to make to the minutes? If not, can I then get a mover for the adoption of the minutes? Our members, if I can get a mover for the adoption of the minutes.
No, Mtetwa moves, Chair.
Thank you, Honorable Mtetwa. Can I get a second, please?
Second, Chair.
Thank you, Honorable Bartlett. The minutes are duly adopted. We're going to the final set of minutes, honorable members, and thank you for your indulgence. The minutes are dated the 26th of November 2020. And in that meeting, we dealt with the committee report on the recognition of customary marriages amendment bill. That was the only item on the agenda in that meeting. In terms of apologies, we received apologies from Honorable Mikalakis, Honorable Dango, and Honorable Mfayela. Yeah, it was also quite a quick meeting, if my memory serves me correctly. Yeah, okay. So if there's no amendment or correction to those minutes, our members can get a mover for the adoption of the minutes.
I move the motion, Chair.
Thank you, Honorable Matsamai. And may I get a seconder, please? Honorable Mtetwa, I see you.
Yes, Chair.
Honorable Mtetwa, seconded. Thank you, honorable members. The minutes are then duly adopted. On that note, honorable members, we've come to the end of the meeting. But I think, as I've indicated with the previous bill we dealt with, that we will be in touch with honorable members when we're ready to then take the processes of the bill further. But also, let me take this opportunity to wish our members well with we're moving in a period of a much needed break. We've done a lot of work within this period of time, even though we had challenges of COVID-19, but the fact that we were able to be on a virtual platform, we have covered quite a lot of ground as a committee, and I think I must thank you for your commitment and participation in all the processes, and I know that this break is a much needed and deserved break for all of us, but be safe during this period, and I hope to see you in 2021 renewed, revived, and refreshed so that we can then take other processes of our work forward. Our members, thank you very much, and this meeting is hereby adjourned.
Thank you very much, Chair Malibongwe.
Thank you, Chair.
Thank you very much, honourable members.